Hello, everyone. I'm Jay Lazega, Lazega Johanson. Welcome to this installment of L&J's Morning Break. We're glad you're here. Thanks for coming in. Thank you for all of the positive comments about this platform and also just reaching out to say hi and checking in with us. We really love that. We miss you guys. We have an interesting program today. We've got Jonathan Benader and Danielle Kaplan, and we're going to talk about what came out of this legislative session in Georgia. Several pieces of legislation targeted at, well, one beneficial to us and two targeted directly at community associations. You guys probably know the legislature's not necessarily been pro-community association for the last several years, and two of these new laws that got passed are good examples of this, but one is certainly a protection, liability protection law related to COVID for not only our amenities, but all of our common areas. So we're going to use our menu bar today that's on the side of your screen. We have a handout of a sign that's part of this legislation, a liability protection sign that you should be using, not only at your amenity areas, but also at your building entrances, parking areas, all of your common areas. It protects business properties. So we've got that there that you can download. We also have a question tab where you can send your questions in or your comments. We will try to answer those in the session. If we don't, we'll get back to you. But please use that, and we love to hear your positive comments. So the three laws from this session that were important is, one was the liability protection law, SB 359 that I've mentioned. We'll talk about that and how that adds some protection for us, although it by no means is a full absolute protection, such that we need to stop following Georgia Department of Public Health or CDC guidelines and protocols. There still are risks to us in opening and operating amenities. But this absolutely helps us some. Two that are not so helpful. One is a new law that limits our ability in some ways to make some new leasing restrictions. We're still able to, but the legislature has put some limitations on how we can apply new leasing restrictions and in HOAs and POAs. And then the legislature also adopted a law, change to the Condominium Act, applying just to condominiums, to change how we process and handle water claims under our insurance policies. In my opinion, completely unnecessary and very problematic for us. But Jonathan and Danielle will talk about those. We're going to start with Jonathan. Thanks for joining us.
Everybody. So as Jay mentioned, I want to start by talking about HB 1070, which is the bill that changed the insurance provision in the Condo Act. It will go into effect on January 1st, 2021. So as you all know, Section 44-3-107 of the Condo Act requires that condominium associations carry fire and extended coverage, but is absolutely silent when it comes to water damage or water perils. So us in the industry have known that to mean that there's no statutory requirement that you carry insurance for water damage or water perils, or in the event that you did voluntarily have such insurance, that you wouldn't have to set a statutory cap on how much of the deductible you would charge back to owners in certain circumstances. So this new law does two things. One, it clearly states that there's no requirement that condominium associations have to obtain insurance for water damage or water peril. So I think that that is a good thing for whatever it's worth. And number two is that it requires that in the event that there's a potential claim for water damage or water peril, the condominium association has to provide the unit owner with a copy of its certificate of insurance upon request by that unit owner. And then this applies both ways. It's a two-way street. So the condominium association could ask the unit owner for a copy of their insurance, as well. And when I say copy of their insurance, I'm talking about the certificate of insurance, not the actual policy. Now, once a claim is actually submitted, then the condominium association has to provide the unit owner with contact information for the insurance adjuster that has been assigned to handle that claim upon request by the owner, and vice versa. So what is really interesting about this law is that it seems to suggest that condominium associations cannot stop someone from trying to file a claim under the condominium association's master policy. You know, in the past, we have advised clients that the board had the discretion to file a claim or not under its master policy. Let's say the amount insurance were to pay out was only slightly greater than the amount of the deductible, the board may decide that it makes financial sense just to pay out of pocket as opposed to filing a claim and potentially raising the monthly premiums for insurance. So now if a unit owner tries to go around the condominium association to file a claim, I'm not really sure what the insurance carrier is going to do in those situations. You know, the condominium association is the named insured under the policy, but most governing documents have explicit language that say that the condominium association is merely a trustee for the unit owners who are beneficiaries under the policy. So it'll be really interesting to see what insurance does in those situations. And it probably depends on how the specific policy is drafted. I imagine that insurance carriers will probably pay out if a unit owner goes around the condominium association to file a claim under the master policy. So if you have any questions, you know, please please send us emails and ask. We're happy to answer them. Right now, I'm going to let Danielle provide an update about SB 359, which is the COVID-19 Pandemic Business Safety Act. All right, thank you.
Good morning, everyone, and thank you for joining us. So as Jonathan said, I'm going to speak a little bit about SB 359, back to more COVID-related issues, which I know is on everyone's mind lately. So SB 359 is also known as the Georgia COVID-19 Pandemic Business Safety Act. And we've received reports that it was signed into law by the governor yesterday. We're not seeing that showing on the Senate website yet, but it's probably safe to say that it is effective now. And even if it wasn't signed into law by the governor, it was going to become effective tomorrow, August 7th. So either way, we should operate going forward as if it is in effect. And this act is really helpful for the association, for associations and other businesses throughout the state. It is definitely to our advantage. It should make everyone feel a little more comfortable. And the main things that it does is that first, it states that when somebody is bringing a claim against the association for COVID-19 related issues, they have this higher bar to meet. According to the act, the association would not be liable for damages for COVID-19 related suits unless the claimant can show either that there was gross negligence, willful and wanton misconduct, reckless infliction of harm, or intentional infliction of harm. So this is definitely a higher standard than just simple negligence. And the act also states that individuals who enter the association's common areas will be deemed to have assumed the risk of potential exposure to COVID-19 if we post a sign that has specific language that's included in the act, and I believe that we're providing as a handout, that is posted in 1-inch Arial font, at least 1-inch Arial font, at the entrance of any common areas. And the sign needs to specifically say, I'm just going to quote now, warning, under Georgia law, there is no liability for an injury or death of an individual entering these premises if such injury or death results from the inherent risks of contracting COVID-19. You are assuming the risk by entering these premises. So if you haven't already, we highly recommend, just to get the benefits of this new law, that you post a sign that complies with these requirements at the entrances of your common areas. I do want to be clear that just because, you know, this is definitely a beneficial law for us, it does protect us, but it's not a catch-all. It doesn't mean that we're entirely safe. And so we're still recommending that all associations at the common areas still use all the methods to protect ourselves from liability that we've been previously recommending. I'm sure you've heard a lot about these before. They include requiring that everyone that enters the amenities signs waivers, new rules that require social distancing and other COVID-related protections, heightened procedures, sanitization procedures, other signage that protects us. So we're still recommending all of these things. And let us know if you need any more information about any of these recommended procedures at the amenities. But we should just rest a little easier that it appears for once that the Georgia legislature is on our side in terms of just protecting us a little bit more, just helping us operate our amenities while not worrying as much about liability and getting the advantage of this act. But, you know, as I mentioned before, it's not an entire protection for us, and we still need to do what we can to protect ourselves from liability. Like I said before, we could still be potentially liable if we are found to have been grossly negligent, willfully and wanton misconduct, acted with willful and wanton misconduct, if we recklessly infliction harm or intentionally inflicted harm. So it's hard to say, it's really hard to know what would be considered gross negligence or what would be considered a reckless infliction of harm. But that's why we just want to do what we can to protect ourselves as much as possible. And again, just let us know if you need help with any of our recommended procedures, signage, waivers, rules, etc., or if you have any other questions about the benefits of this bill. And I'm just going to turn it back to Jonathan to discuss additional legislation.
Okay, thanks, Danielle. So I wanted to quickly give an update about SB 442. This is the bill that mandates grandfathered status for people that were leasing before the imposition of leasing restrictions. I know that a lot of us in the industry were not happy about this bill. It's my understanding that the bill came about from investment groups that wanted the unfettered right to keep leasing, and that it was being promoted by the retail lobby. Sorry, not the retail lobby, the real estate lobby. So let me first talk about its impact. Sorry, not the retail or real estate, but the realtors. I misspoke there. So first, let me talk about its impact. So the new law does not apply to condos, nor does it apply to common law HOAs. It only applies to POAs. That said, common law HOAs are indirectly affected because they have to submit to the POA Act for leasing restrictions to be effective against 100% of the community as a result of the Charter Club case. The Charter Club case basically held that if you were to impose restrictions, greater restrictions on the use of someone's land, that person would have to consent. But the Charter Club case doesn't apply to POAs. So in short, what this law says is that you have to now grandfather existing leases for so long as the investor owns the lot. One good thing, however, is that you do not have to grandfather in leases that are less than 6 months. So I think that an amendment that deals just with short-term rentals like VRBO and Airbnb should be okay. Also, we think that maybe an amendment that imposes leasing fees would be okay as well. It wouldn't fall under the parameters of this new law. But it should be pointed out that any rules that are onerous could be determined to be a prohibition or restriction on leasing, which would be a violation of the new law. And I know that we've sent out a couple of e-blasts about this before, so really this was just meant to be kind of an update. And so I hope that you've enjoyed our time this morning. I'm going to let Jay pop in at the very end here to wrap things up.
Thank you, guys. That was great. So quick final thoughts on the COVID issues, and then I want to talk about very quickly annual meetings and elections. The liability law, protection law is big, but there clearly still are paths for people to argue liability. Plaintiff attorneys are they're going to use that reckless conduct avenue and say that you didn't do enough. Even with the law and even with CDC guideline compliance and Georgia Department of Health, public health guideline compliance, the rest of the world and the health professionals are saying you shouldn't even be open. And we do think that you can defend decisions to not open if that's where your community or communities are right now. And if you are open, you certainly do it safely, but we're hearing significant numbers of reports from our communities. Okay, we've been notified of somebody infected in the community and they were at the pool last Saturday. What do we do? And certainly we got to do communications to the community to let people know. But by the time you start having the second and third of those, okay, we've now had the second person notify us. We're in a much different position, and it's certainly fodder for the plaintiff attorneys to potentially make claims against us. So absolutely, if you're opening, you're operating, do it safely, use the signs. We've got sample signs on our resources section of our website at ljlaw.com resources. We have, definitely feel free to use those. Sample signs, sample policies, sample waivers, sample letters to your owners to use whether you're opening or not opening. So feel free to visit that. We hope you do. We've got videos, these, on many topics on the website and on our Facebook page, our YouTube channel. So use those. We have one, and we're planning a longer one on, we must do annual meetings and we must do elections, even during the pandemic. So certainly it doesn't make sense to do that physically live this year. And that's okay. There are methods for us to accomplish that. For most communities, depending on your documents, you'll be able to do your elections. You'll be able to do your meetings virtually, your annual meetings. You'll be able to do your elections probably virtually too, but that's very complicated. We think what you really should do is do your elections by a separate balloting method, whether it's using one of those online voting platforms, or for most communities, it'll be easier just to do some form of mail-in ballots. Visit our other videos on that and join us, ask us questions about that. Join us when we do our next video on that, the longer one, but very key point. You need to start planning now for your annual meetings if you're November, December, maybe even January. It takes longer to do elections and meetings with these methods. So whether we are your lawyers, hopefully we are, or we are not, got to start talking to your lawyers to get your plan in place on how you're going to accomplish that. Okay, thanks for joining us. We miss you guys. We can't wait to see you guys again. In the meantime, stay healthy, be good. We hope you're well. Thank you for joining us.
Thanks.